Good afternoon, everyone, and thank you so much for joining me for part 3 of our series on privilege. My name is Luka, and thank you all for ignoring the lovely sunshine outside to come and listen to me talk about legal advice privilege. That is the topic of today's webinar. Hopefully you're expecting that. Some of you may already have seen in part 1 of our series, I addressed litigation privilege, and in part 2, my colleague Osti Mahler addressed the question of without prejudice privilege. If you missed either of those and you're interested in either of those topics, copies of our presentations are available online on our website. Today, I'm going to talk about legal advice privilege, as I've said. And as usual, at the end of the seminar, you will all be sent a copy of my handout, which contains a list of all of the references that I have referred to, and which hopefully will contain lots of material to help guide you in the right direction when you're dealing with points of privilege in your own disputes. You'll also be sent a copy of my slides as well. So please do make sure that you're on mute, and please do make sure that your camera is switched off. Otherwise, you might make a surprise cameo in today's webinar. And if you've got any questions, please feel free to enter them into the chat function, whether as a private message to me or publicly, and I'll deal with any and all questions at the end. Now, legal advice privilege is something which protects an incredibly important matter. It is a privilege that exists to ensure that our clients are able to gather clear and honest advice based on their truthful instructions without fear that any of their concerns or hesitations will be expressed or exposed in a trial. And that purpose was recently summarized by the Court of Appeal in the case of Jet2.com, which I'll be talking about later in the following terms. A person must be able to consult their lawyer in confidence, since otherwise they might hold back half the truth. And that, in a nutshell, really emphasizes the policy that is at play here. The courts want to encourage people to be able to speak truthfully and candidly with their lawyers so that they can get accurate and honest legal advice and make informed decisions how to proceed. And recent Court of Appeal judgments have emphasized that where legal advice privilege is established, it is more or less ironclad, and with very few exceptions, it will remain intact. Even according to the recent case of Adelsey and Denton's, if advice is given to a company and that company is later dissolved, legal advice privilege is maintained, even beyond the grave, so to speak. I've always thought that legal advice privilege is one of the more deceptively simple areas of privilege and of procedural law generally. Quite often when we're doing disclosure reviews, it's easy to assume that any email that has a lawyer CC'd into it or any document which refers to a lawyer will be protected by legal advice privilege. But in reality, there is a lot more complexity than that, and there are a lot of gray areas. And what I'm going to try and do today is to talk you all through the key elements of the test for legal advice privilege. And I'll give you an update on some of the more recent authorities and the important things they've had to say with regard to the test. And then we're going to look at some practical tips on how you might be able to deal with challenging issues of privilege in your own cases. So let's begin just by looking at a simple definition. And on the slide, you can now see a definition that I've taken and slightly adjusted from Passmore's book on privilege, which is one of the many excellent guides to this area of law. He defines it in the following way. Legal advice privilege will apply to communications, number one, between a client and his lawyer, where the lawyer is acting in the course of their professional relationship and within the scope of his professional duties. Number two, where the communication is under a condition or conditions of confidentiality. And three, where the purpose, and in fact, as a result of a recent decision, the dominant purpose of that communication is to enable the client to seek or the lawyer to give legal advice or assistance in a relevant legal context. Then, if all of those criteria are fulfilled, privilege will arise. Privilege is, of course, a right of the client, and it is the client who's entitled to assert it. And the client is the one who will bear the burden of proving it if the court has to determine whether or not a claim for legal advice privilege is properly made out. Now, for today's purposes, I think it's helpful to approach it in the following stages. And I've broken down the different elements of the inquiry, and we'll look at each of these steps in turn. First, there are what you might call the identity questions. Is there a person who can be deemed a lawyer? And is there a person who can be deemed a client? Those are absolutely essential threshold questions. And if you don't meet that very first hurdle, then no question of legal advice privilege can arise. Secondly, there's what you might call the context question. Are the communications confidential? Were they sent and received under conditions of confidentiality? And thirdly and finally, and which is the subject of most of the debate in most cases, there's the question and questions really of subject matter. So you must be able to show A, that there was legal advice in a relevant legal context, B, that the legal advice or the continuum which led to that legal advice being given was contained in communications, and thirdly, in light of the recent Court of Appeal judgment in Jet 2, the case I've alluded to already, there is the dominant purpose test. Communications must be sent or received for the dominant purpose of obtaining legal advice. So with that overview, let's turn now to look at the identity questions. And let's begin by looking at the identity of the lawyer. Now, in many cases, this will be an incredibly simple question to ask, but it can also be an extremely important one. I think the identity question when it comes to a lawyer can helpfully be broken down into two parts. The first part is a question of qualification, and the second part is a question of capacity, you might put it. The first question, the qualification question, often will be very simple, but it's still very important to have regard to the limits here. As was confirmed by the Supreme Court in the case of Prudential and Special Commissioner of Income Tax in 2013, accountants, for example, cannot be treated as lawyers, and communications involving legal advice or purported legal advice from them is not advice to which legal advice privilege attaches. And that's even if the subject matter of those communications from the accountants is good quality or accurate legal advice. What was said by Lord Neuberger at paragraph 32 of that judgment was that legal advice privilege is limited to communications in connection with obtaining legal advice from qualified lawyers. And I'll just reiterate there for anyone who's joined us, all of these cases will be on the handout that I'm going to send you after this. So don't worry too much about scribbling down any of the individual names. So in terms of qualification, we're looking for solicitors, barristers, members of the Chartered Institute of Legal Executives and so on, people who are qualified as lawyers and also who are regulated as lawyers. That can be a very, very important litmus test. Just to clarify, because it's a question that I was actually asked on LinkedIn before this seminar, what's the status of trainees or paralegals? Well, Bankham Thankey, in one of the leading texts on privilege, the law of privilege, confirms that trainees and paralegals can indeed attract legal advice privilege, provided that they are under the supervision of a qualified individual. And it's likely that if there was ever a case where this issue was tested in court, what the court would be looking at is not simply that there was formal or theoretical supervision, but that there was actual substantive supervision on the part of a qualified individual. An important point when we're talking about qualification is that the legal qualification and regulatory status have to be current. So in a case from 2008 called Dodurian and Sims, the court confirmed that where a solicitor had been struck off the roll, then legal advice privilege in principle would not attract or attach to the legal advice purportedly given by that individual. They lack the necessary qualification. There is an important exception to that, and it's a carve-out which exists to protect innocent clients. And that is that if someone, and I'm quoting the words of the judgment here, mistakenly believes that they have instructed someone in good faith to be a qualified solicitor or barrister, then they should not be required to forfeit the protection of legal advice privilege. And that was based on a much earlier case, many, many years ago, in which a claim for privilege was upheld, where a client had sought legal advice from a friend who he thought was a solicitor, and indeed had been a solicitor, but had ceased to practice without the client's knowledge some years before. So those are some important considerations when it comes to qualification. One interesting question, which I'll flag up here, and which really could be a talk in and of itself, is what about foreign qualifications? What about the case where you have a foreign qualified lawyer? And in today's increasingly international and increasingly commercialized world, that's something that we see very, very often indeed. There's not a great deal of case law on this. And as far as I can tell, there are only really two high court decisions. And both of those support the view that advice from a foreign qualified lawyer still is advice to which legal advice privilege attaches. And I say that because one of those cases I was involved in, and it was the Sheffield United ownership dispute, which came to trial last year. One of the issues in that case was that one of the parties to an English law contract, which governed the co-ownership of Sheffield United Football Club, was a Saudi prince called Prince Abdullah bin Abdulaziz bin Mossad Al Saud. And he was one of the parties to the litigation. And at various points in the chronology leading up to the litigation, he had received emails and documents from a man that was described as effectively being his right-hand man, a man that we, and I should say I was representing the opponents in that case, described as effectively a fixer, someone who was involved in addressing all sorts of the prince's business and financial interests. And we said that because that particular individual was a Saudi qualified lawyer and not an English qualified lawyer, it was unlikely that he was able to give legal advice in respect of an English law contract. And what the Chancellor, Sir Geoffrey Voss, concluded was that as a matter of principle, a foreign qualified lawyer can give legal advice to which legal advice privilege attaches. And it's a common sense decision, and it's especially logical if you're dealing with cases where there is an international element. Having said that, it's very much a point that's up for grabs, and I wouldn't be surprised if we saw it being disputed at an appellate level in due course. Even if in principle a foreign qualified lawyer can give advice on an English law contract, it may be possible that in some cases, the fact that someone is a foreign qualified lawyer suggests that as a matter of fact, they weren't really giving legal advice per se, but in fact, they might have been giving more commercial advice. And we'll come later on in this talk to discuss that very important subject matter question. So leaving aside the issue of qualification, let's turn and discuss briefly what might be called the question of capacity. Now, I'm just going to share with you the following slides. And this is an extract from a case that dealt with the question of in-house lawyers. Again, this is one of the questions that is often asked of me. Do in-house lawyers attract legal advice privilege? And the short answer is that in principle, they absolutely can. And there's a long list of cases, including the Court of Appeal's judgment in 2020, which confirms that in-house lawyers can very much give advice to which this privilege attaches. And that is the sentiment that's reflected in Mr. Justice Moore Bick's comments at the beginning of the extract that's on the slide. Lawyers do not cease to be regarded as professional legal advisors simply because they're employed by their clients, for example, in a legal department. However, what his lordship went on to address was the question of capacity and the different roles that in the modern commercial world an in-house lawyer might fulfill. And this is why the question of capacity is so important. And it's something that we'll return to later in this talk when we deal with subject matter. He says, people who are employed in that capacity, i.e. in-house, are more likely than independent practitioners to become involved in aspects of the business that are essentially managerial or administrative in nature. To that extent, it is less easy to maintain that all communications passing between them and the company's management attracts privilege. So you must always consider whether the in-house lawyer is acting in their capacity as a lawyer. And there have been a number of cases in which documents between in-house lawyers and people from the very same company have been held not to have legal advice privilege to attach to them. For example, in 2018, there was a case of Glaxo Wellcome and Sandoz Limited. And in that case, external solicitors were involved. And the role of the in-house lawyer was, in effect, to transmit instructions to those external solicitors. And so the High Court concluded that communications between the in-house lawyer and other members of the same company were not between a lawyer and a client, because the in-house lawyer was not acting in the capacity of a lawyer. That deals with the question of the lawyer and their identity. What about the client? Well, this is a very frustrating area of the law, and anyone who's been involved in dealing with questions of privilege in the last 15 years knows that. And that frustration follows on from the decision in Three Rivers number 5. And this was the case which arose out of the collapse of the Bank of Credit and Commerce International, in which the Court of Appeal said this: where you're dealing with a company or a corporate entity, that is the client. So the entity is the client. But legal advice privilege will only attach to communications between a lawyer on the one hand, and on the other hand, a person who has been authorized explicitly or implicitly to be involved in the gathering of legal advice or the giving of instructions. So it's quite a rigid and quite a difficult test there, because what the Court of Appeal has said, and this has remained binding authority and is to this day, is that you will have many people in a company who might be involved in preparing documents which are later sent on to lawyers, but if they are not people who are authorized explicitly or implicitly to obtain advice or give instructions, then they cannot be treated as having acted on behalf of the client. They're not an emanation of the client, if you will. And so the criteria for the lawyer-client relationship is not met. And that's a very, very harsh test indeed. It's even been held in one case recently, the RBS rights issue litigation in 2017, that where internally lawyers had interviewed a number of people for the purpose of gathering evidence, Mr. Justice Hildyard said that the very stringent test that was applied, and which was law pursuant to Three Rivers, meant that often you would have individuals who are authorized to gather or provide information to lawyers, but that does not mean they are authorized to receive advice or give advice. And so in the case of those interviewees who had given information to the solicitors, they were not people who were able to act on behalf of the client. And so legal advice privilege could not attach. I've set out on the slide a useful summary of the law as it currently stands from Thankew's book. And I've set out a few bullet points that can help answer this question of whether or not someone is authorized explicitly or implicitly to be involved in giving instructions or receiving advice. Consider their job and the job description generally. Consider their role or their appointment with respect to legal issues. If there is any email or document that shows that they have been appointed to deal with a particular legal issue, then that's very helpful indeed. And equally consider their practical involvement in decisions taken in connection with legal matters. If, for example, they were involved in advising the board on a decision whether or not to pursue litigation, that would be very strong evidence that they were, at the very least, implicitly, if not explicitly, authorized in connection with legal advice. So that concludes the identity questions, the question as between the lawyer and the client. The second stage that I mentioned earlier was the requirement of confidentiality. Communications must be between a lawyer and between a client, and it must be confidential as between them. In a slightly older case, a case called Crown and Braham and Mason, a man was being interviewed at a police station and his solicitor came along. And at one stage, he was speaking to his solicitor in a public area of the police station, and the conversation was overheard by a police officer. And the court concluded that privilege did not attach to that situation because the conversation was public. It was not taking place under conditions of confidentiality. So it's always important to be very careful when you're going through a disclosure exercise or potentially challenging another party's claim to privilege to consider whether or not the context suggests that conditions of confidentiality applied. If emails are being sent internally between the lawyer and between a small group of people at the client, then obviously that would strongly suggest in the usual case that confidentiality applies. And Bankintanki in his textbook suggests that a useful litmus test for confidentiality is this: ask yourself the question, would the solicitor be at liberty to disclose the information? And if the answer is that they wouldn't, and if the situation is such that the client would expect it to remain private, then that satisfies the requirement of confidentiality. Just for the avoidance of any doubt, despite the very stringent test that applies in respect of determining who can be treated as the relevant client, which I mentioned a little bit earlier, once advice is given, so once advice is properly given by a lawyer to someone who is authorized, in effect, to act as the client, if that advice is then disseminated internally within the company, so it maintains that confidential character and doesn't make its way into the public domain, then confidentiality is met or confidentiality is maintained. So it's not lost simply because it goes beyond the initial pool of people who were instructed implicitly or otherwise to be the client. So that leaves us with the third and perhaps most complex stage. And this is the question, or these are the questions of subject matter. And the first and most important of these, or one of the most important, I should say, is the question of legal advice. For this privilege to attach, you must be able to demonstrate that the communication in question concerns legal advice given in a relevant legal context. And after we've talked through that, we're going to talk about the fact that that legal advice must be contained within communications, or that communications which form part of a continuum in which legal advice was gathered can also be protected. And then thirdly and finally, we're going to look at the dominant purpose test. But for now, the seemingly deceptively simple question, as I said, what is legal advice? Well, a useful touchstone is the judgment of the House of Lords in Three Rivers, this time Three Rivers number 6. And in this case, the court said that in cases of doubt, the judge called upon to make the decision as to whether or not privilege attaches should ask whether the advice relates to the rights, liabilities, obligations, or remedies of the client, either under private law or public law. If it does not, then, in my opinion, legal advice privilege would not apply. So that is an extremely valuable touchstone to have. Is the advice concerned with rights, liabilities, obligations, or remedies available at law? If it is, then that is a strong pointer that legal advice is being given. But you always have to consider whether or not the advice is legal advice, as opposed to, for example, commercial advice, or perhaps general PR or reputational advice. It's important to emphasize, however, that legal advice is not confined to telling the client the law. So it's not simply sending them emails telling them this is what the law says, this is what this statute means. It also includes advice as to what should be done in the relevant legal context. So the practical decisions to be made in light of the questions of rights, liabilities, obligations, or remedies, those are protected by legal advice privilege. That is legal advice in the relevant legal context. It's also been said in the Three Rivers judgment number 6 itself, that if a lawyer who is addressing the questions of rights and obligations also addresses the commercial wisdom of a potential transaction or decision as part and parcel of the same advice, then that should be covered by legal advice privilege as well. And that is a very valuable clarification to have. The real issue and the concern of the courts here is to make sure that privilege does not attach or should not be allowed wrongly to be claimed in a situation where a lawyer is giving, for example, pure commercial advice, something that has no relation whatsoever to questions of rights, obligations, or liabilities or remedies. In that case, legal advice privilege should not attach. And often the key question for you will be whether the lawyer is acting in their professional capacity as a lawyer. Remember that, to put it simply, people can wear different hats, and the fact that someone is qualified as a lawyer doesn't necessarily mean that at all times they are acting as a lawyer. In order for privilege to apply, they must be acting in that capacity. And this hails back to an old case from 1948 called Blackpool Corporation and Luka. And that was a case in which a solicitor also, in his part-time, worked as a town clerk. And in the underlying facts, that solicitor / town clerk had had a number of communications with the minister of the Blackpool Corporation, which was the subject of proceedings later on. Privilege was claimed over those communications, and it was asserted that this man is a solicitor, and so he was giving legal advice within the scope of a client-lawyer relationship. But the court rejected that argument, and the court held that the solicitor was representing his corporation in an executive and not in a legal professional capacity. And that's a judgment that I've had a number of arguments over in my own cases. And perhaps the most important concept is the following one, which I'm going to show you on the slide, another passage from Three Rivers number 6. And this is the concept of the man of business. Of course, person of business, it shouldn't simply be confined to man of business, but that's the phrase that was used in the judgment, and that's why I'll use it here today. In Three Rivers, it was said that if a solicitor becomes the client's man of business, as some solicitors do, and if they're responsible for advising the client on all matters of business, including investment policy, finance policy, and other business matters, the advice may lack a relevant legal context. There is, in my opinion, no way of avoiding difficulty in deciding in marginal cases whether the seeking of advice from or the giving of advice by lawyers does or does not take place in a relevant legal context so as to attract legal advice privilege. So in some circumstances, you may have a lawyer who is acting as the so-called man of business. And if they're operating in that capacity, and if the work that they're doing is not directly related to their professional duties, if it's, for example, something that wouldn't fall within the scope of the lawyer's retainer, if it's something that wouldn't be regulated by their relevant regulatory authority, then there may be a strong argument that it's not legal advice or it's not within the relevant legal context. One example that was given in the cases is that if a person's lawyer was tasked with collecting rent on commercial properties, i.e. fulfilling an administrative property management type task, they will not be acting qua lawyer. They will not be having their lawyer's hat on. So these considerations are extremely important, especially in cases involving in-house lawyers. And you may need to consider whether or not the in-house lawyer on the facts of your particular case was performing an executive function as opposed to a legal one. The next stage of the test is to consider the question of what we mean by communications, because the case law is quite clear that privilege attaches to communications which contain or concern legal advice. Some valuable guidance is given again by the case of Three Rivers number 6, in which the court said legal advice privilege is restricted to communications between a client and his legal advisors. That's number 1, and the most obvious example of a communication where a lawyer sends a document containing advice to their client, or indeed where the client sends a request for advice or documents upon which advice is needed. Number 2, it also extends to documents that evidence such communications. So secondary evidence. So if, for example, you were able to say that you have an email which someone within a particular company sent to another person in the company saying, we spoke to the lawyers 2 weeks ago, this is what they advised, then that would also be cloaked by the protection of privilege because it's reflective of the initial legal advice. And thirdly, documents intended to be communications, even if they were not in fact communicated. And that third point is potentially quite an important one. The essence of communications is obviously that a communication traditionally has to cross the line. It has to go from one person to another. But thankfully, there's clarification in cases including Three Rivers that if a document is prepared with the intention of being a communication, but for whatever reason, it isn't in fact actually sent, nonetheless, it can be deemed a communication. So for example, a draft letter of instructions to counsel, a draft email which contains numerous questions or concerns about a dispute, even if it was never sent to a lawyer, even if it was a very early draft, for example, can still be protected by privilege. And it's also worth emphasizing, as I alluded to already, and as was confirmed recently in the jet2.com case by the Court of Appeal, that legal advice privilege will continue to apply to communications that were disseminated internally within the company that represents the client. Just as an important practical note, however, attachments are not necessarily going to be protected by privilege. Say for the sake of argument, you have an email which forms part of the continuum in which legal advice is sought from a lawyer. That doesn't necessarily mean that automatically the attachment, which may have been a different document performed or created rather for a different purpose, will itself be privileged. So the case there is called Immerman and Chenguiz from 2009. And the established principle is that non-privileged documents cannot acquire privilege simply by being sent to lawyers. And in the jet2.com case, handed down in February of this year, the Court of Appeal confirmed that on that basis, an attachment to a privileged email is not necessarily privileged by association. You need to conduct a separate independent inquiry into it. So with that in mind, we'll turn now to the third and final part of the inquiries, or the stages of inquiry that we've looked at today, and that is the dominant purpose test. And that brings us finally to discuss in some detail the case of jet2.com that I've been referring to on so many occasions. And it's a case that I'm sure will be familiar to many of you. Just to give you a little background to the case itself, to anyone who's not read into it. What happened and what gave rise to this case was as follows. The Civil Aviation Authority, CAA, issued a press release which criticized an airline, jet2.com, for not having signed up to a voluntary alternative dispute resolution scheme that the CAA had come up with. Jet2 then wrote to the CAA and took issue with the content of that press release. In response to that, the CAA sent Jet2 a letter which reiterated its criticisms, and then the CAA also leaked that correspondence, the correspondence between itself and Jet2, to the press. Jet2 then sought a judicial review of the CAA's decision to both issue the press release and to leak the correspondence to the press. And in the course of those proceedings, the judicial review, Jet2 applied for disclosure of various documents, including all drafts of the CAA letter and all records of any discussions concerning the drafts. And in this case, in a very detailed judgment, which is very much worth reading in full, the court considered a number of essential propositions concerning legal advice privilege. And just to flag up for the sake of convenience, paragraph 42 onwards of the judgment is where the Court of Appeal begins to set out the essential propositions. And it then contains a summary of those essential principles and their application at paragraph 100. And one of the questions that the court had to consider is whether or not, in order to make good a claim for legal advice privilege, you need to be able to demonstrate that the dominant purpose of a particular communication was for obtaining legal advice, as opposed to, for example, commercial input. And this has been a highly contentious question for a number of years. A lot of very well-respected commentators suggest that the dominant purpose test should not play a role in legal advice privilege. But ultimately, the Court of Appeal held that there should be a dominant purpose test. And they were swayed quite heavily by the fact that in litigation privilege, there is also a somewhat different dominant purpose test, i.e. that communications or documents have to be prepared for the dominant purpose of litigation, which was reasonably in contemplation. And as I mentioned already, that was the subject of the first seminar that I did in this series, which is available online. So as a result of the Court of Appeal's analysis in the Jet2 case, it is now also the case that if you are trying to make good a claim for privilege, you must be able to show that the dominant purpose of a particular communication was either to seek or to give legal advice. And where there are situations where there is a mix of legal advice and commercial advice, it's very important to be careful and very particular as to whether or not you can properly demonstrate that the dominant purpose was legal advice. I'm just going to turn now to a couple of practical tips. And these tips are just intended to give you a very brief overview of how you might go about tackling issues of privilege in your own cases, whether you are acting for the party who is claiming privilege and therefore the party that bears the burden of proving privilege, or if you're acting for a party that wants to challenge another side's claim to privilege. These same practical tips were set out in my earlier seminar on litigation privilege, so I'll just skim through them in overview. The first point to note is that if you are asserting privilege, it's very valuable to be as clear and specific as early as possible. Of course, at a very early stage of a disclosure review process, the sheer number of documents involved means that you can't realistically devote paragraph after paragraph of analysis in respect of each individual document. It's likely that they'll be sorted into a particular folder for documents that are seen to be privileged. But if a dispute arises, and if it's anticipated that there will be a dispute over privilege, then it can be really strong to have a very clear idea from an early stage and a clear analysis of why you say these documents are privileged. That can be very helpful if at some stage you have to take this battle to court. If, on the other hand, you are challenging privilege, the first and most important thing to do is to seek information about the claims to privilege made by the other side. Don't jump the gun and make an application off the cuff. If, for example, the only information that you have from the other side is that we have withheld 20,000 documents because they seem to be privileged, you will do yourself and the court no favors by making an application seeking inspection of those documents at that stage. One case which can be quite helpful in terms of gathering information is Astex and AstraZeneca. The court has the power to order a party to provide information effectively pursuant to Part 18 and in the form of a schedule. And given that the court can do that, I've often found it quite helpful to write to the other side and say, in line with the guidance there and in the interests of cooperation, please could you provide us with information as to why and how you assert that privilege attaches to these documents that you've withheld. My third tip is that if you find yourselves in a deadlock where one party is claiming privilege, where they've explained why they're claiming privilege, but the other party is not satisfied by the claim for privilege, say for the sake of argument, it's a situation where you consider that someone who might be a qualified lawyer is in fact acting as a so-called man or person of business, always try and consider cooperative methods for resolving the disputes. In many cases, it will be enough for a clear witness statement from the party claiming privilege to explain why they're privileged. But if there's a grey area, you might, for example, consider whether or not you could enter into a confidentiality agreement and have lawyers on the opposing side, the challenging side, look at the documents and confirm whether or not they are in fact privileged. And the confidentiality agreement can, of course, provide that they will not use the information that they've gathered for use in the litigation itself. Obviously, that can be, in many cases, a very difficult thing to recommend to your own client, especially where there are concerns over commercial sensitivity. If an application is necessary, make sure your evidence has detail. And in the next slide, I'm going to talk about what sort of detail I have in mind. And always remember at point 5 that the court has the power to inspect documents itself to determine whether or not the claim to privilege is made out. And that's contained within CPR 31.19 and replicated at paragraph 14.3 of the provisions of the disclosure pilot. The Sheffield United case that I was involved in, which I mentioned earlier, was one example of the court exercising that power. And the court has a discretion to view documents itself, but that's a discretion that will only be very cautiously exercised and only where it's a matter of absolute last resort to resolve a very serious dispute. And in reality, it's only if you can demonstrate that the documents which are disputed, or rather where privilege is disputed, are likely to be of massive importance to the case as a whole. Finally, just some practical tips in terms of your evidence. Consider these points. If you are putting together the evidence, trying to defend or make good a claim for privilege, or equally, if you are looking at someone else's evidence, which is attempting to make good a claim for privilege, you might want to ask yourself some of these questions. Number one, does the evidence explain the identities of the individuals involved? Does it explain and does it satisfactorily explain that one person is a lawyer and the other is a client, or someone who, within the meaning of 3 Rivers number 5, is able to act on behalf of the client? Does it consider the capacity in which the lawyer was acting? So, for example, in the case of an in-house lawyer, does the evidence clearly explain that that in-house lawyer was fulfilling the lawyer's role rather than being someone, for example, who was responsible for providing information onto an external lawyer? Number 3, does the evidence address the involvement of further individuals? So this could be relevant to considerations of confidentiality. If, for example, you know that there are emails that were shared with third parties, you might be able to, or you will have to at the very least consider whether or not the claim for confidentiality can be maintained. Number 4, is it a communication? So that goes back to the simple test. At face value, a communication must have crossed the line, but there are exceptions to that, including draft or inchoate documents, documents that were intended to be sent, but which were not sent. Number 5, does the document, or rather the evidence that's now being prepared, confirm that legal advice as opposed to non-legal advice was sought or given? I've dealt with quite a few cases where the evidence is quite unclear on that matter. And given how important it is to be able to show that the subject matter was truly legal advice, that's a very, very important point to address. And 6th, and this is perhaps the key new point in the wake of the Jet 2 decision, does the evidence address the dominant purpose test? The greater the degree of clarity, the better. And I derive that from the case of Starbev, which is cited here on the previous slide. You need to be able to explain a claim to privilege in detail and with clarity. And the more clarity, the more likely you are to persuade the court that your evidence in the form of a witness statement or affidavit, if necessary, is good evidence that this is a privileged document. If, however, the evidence is vague, if it doesn't address the dominant purpose test, then there might be a greater risk that the court would be willing to go behind the witness statement and, for example, inspect those documents personally. So that concludes my practical tips. And that concludes my part of the seminar. Thank you all very much for listening. I'll be sticking around for the next 10, 15 or so minutes if other people want to answer any questions. I can see already from the chat function that we've got hopefully some questions. So let me look at those now. So, well, these are some very detailed questions that I've got here, and I may need to ask if those people would be happy to email me separately so that we can look into them, but let me see. So first question that I have, what to do about situations where there are multiple people, multiple addressees to an email. So this is actually something that was addressed in Jet 2, and to the person who's asked that question, it may well be that that is something that you're interested in exploring more about. Paragraph 100 of the jet2.com judgment is the section which deals with multi-addressee communications. And amongst other things, they say this, that an email sent by a client to a lawyer is privileged, provided, of course, that it meets the dominant purpose test. But of course, it won't be privileged if a lawyer is being asked for commercial input. What you always need to go back to is that dominant purpose test. And if in reality an email sent to multiple people is for the purpose of gathering generalized input on commercial views. So for example, if you have an email which is sent to 4 members of the company, plus with a lawyer CC'd in, that's unlikely to meet the dominant purpose test, even if a subsidiary or secondary purpose is simultaneously to obtain legal advice from the lawyer addressee. One of the really important things that the court considered in jet2.com is that there is some benefit to considering an email with multiple addressees as effectively a number of separate different emails. And to that, you apply the dominant purpose test. The Court of Appeal also said, I should say, that there may be some benefit in asking the question, if this email was sent to a lawyer alone, would it have been privileged? And that's actually quite a helpful question to ask, because if in reality the email is raising all sorts of queries about commercial advice, the commercial direction of a company, matters of PR, and then if you ask yourself the hypothetical question, does this meet the dominant purpose test if it was sent solely to the lawyer? The answer would probably be no, because in reality, there isn't much of a request actually for the lawyer to give legal advice. And certainly it would be difficult to suggest that the dominant purpose of that communication was that. So I hope that gives a summary answer. I should say, out of more general application, my email address is going to be at the bottom of the handouts that will be sent to you shortly. So if you have anything further that you want to add to that question, please do follow up with me privately. Another question that I've got here, question regarding the client. Where a lawyer advises a third-party HR consultancy firm who are instructed by the company, and the lawyer gives advice to the HR consultancy, which is passed to the company, does legal advice prevail on passing the information from the HR consultancy to the company? So we have a situation where the lawyer is advising an HR firm, and the HR firm is itself instructed by the company. So in effect, the client per se is the HR firm, but the purpose of the legal advice being sought by the HR firm is presumably to assist the company. What will be really important there is to consider the question of confidentiality and the manner in which that information is shared. It certainly could attract or maintain legal privilege. One of the important cases to bear in mind is a case called City of Gotha and Sotheby's, and that deals with a situation where advice is shared. And one of the phrases used in that judgment, the City of Gotha judgment, is that provided the communications are intended to remain confidential as against the world, or as against the world at large, then privilege can be maintained. So especially if you've got a confidentiality agreement in place between the HR firm and the company, which I would expect that you would do if the sole purpose of the HR firm is to assist in private and important matters, then that might be strong evidence to say that advice received by the HR firm was only confidentially transmitted to the company. So you may well have a very good argument there. I hope that answers that question. Please do feel free to email me if you want to explore it any further. Let me see. witness statements taken by a lawyer appointed by an employer following an industrial accident, would they attract privilege on the ground that the dominant purpose was the investigation of the accident required by, for example, health and safety legislation? I think that actually may be a more litigation privilege centered question. And by way of summary, I think what might help, if you're interested in exploring a situation like that, would be to look at the handout and the slides that we've produced on litigation privilege. Because if you're able to show that the dominant purpose of obtaining evidence was to, in the short term, deal with health and safety legislation compliance, but that actually that was part of a single wider purpose, to use the phrase used in some of the cases. So if there's a single wider purpose of avoiding litigation, you may well be able to say litigation privilege applies. Of course, it will depend on the precise facts and you'll need clear evidence regarding purpose. But what you might be able to say, for example, is that the purpose of gathering this evidence, yes, in the short term, was in order to comply with health and safety legislation. But of course, the reason for that is that if the company didn't comply with health and safety legislation, then they might be at risk of a criminal prosecution. And so on one analysis, there is a single wider purpose there, which is to avoid litigation, to avoid adversarial proceedings being instituted in respect of a breach for health and safety legislation. Again, if you want to explore that question with me further, please don't hesitate to email me. Next question. Attachments to emails should be considered as separate documents from the email itself. Do you know whether there is a position about embedded documents, i.e. PDFs inside a Word document? Would you have to consider that embedded PDF as a separate document or consider it as part of the Word document? That's interesting. I don't think that there's anything absolutely decisive on that. The focus of the Jet 2 decision would be solely on attachments to emails themselves. But within an embedded PDF, I think the safest route would be to consider it as a separate document and to consider the circumstances in which the embedded PDF was created. And that would potentially, provided that the purpose for which it was created complies with and gives rise to legal advice privilege, that would probably be the safest way to proceed. One of the judgments that we talked about when we were dealing with litigation privilege a couple of weeks ago was a recent judgment of the Court of Appeal, which considered the situation where a settlement authority, or rather a settlement agreement, included reference to documents that were otherwise privileged, and the use of the documents within that settlement agreement effectively amounted to a waiver of privilege or the loss of the privilege. My instinct, and I'm happy to look into this in further detail to the person who has asked that question, but my instinct would be that it would be appropriate to consider it as a separate document, because albeit that it's embedded, it is reflective of the contents of an original document that was presumably created in a different context, maybe only a very subtly different context. But I think that would be the wise approach to take. But again, I'm happy to follow up on that. Do drop me an email if you're interested. Separate question. If business client wants a copy of advice, is this covered? i.e. someone not in the original client group. So what I assume the question is here is that if you have someone who was not originally authorized, or authorized explicitly or implicitly to give instructions or receive advice, but they subsequently asked for a copy of the advice, would that be covered? The short answer is yes, it could be, because as I've said, evidence which is secondary evidence of legal advice that was previously given, provided that in the first place the advice was properly given by the lawyer to a properly designated emanation or representative of the client, then any subsequent evidence which reveals the content of that ordinarily would be privileged, provided, of course, that you can satisfy the confidentiality requirement. And that's always an important thing to go back to. If there is any consideration of sharing a document with someone else, I would always make clear that there is a clear paper trail which shows that it's being shared solely on confidential terms. If possible, you might even want to have a confidentiality agreement. I'm assuming here for the purposes that you're talking about a third party. Whereas if you're talking about someone internal to the company itself, ordinarily that wouldn't be necessary. Ordinarily the context would be sufficient to give rise to an inference of confidentiality. So I hope that answers that question. Again, please don't hesitate to get in touch if you have anything further following on from that. Next question, do I have any thoughts on clients accidentally waiving privilege, e.g. by telling other parties that they have relied upon legal advice in taking certain actions? That's a really interesting question. And to the person who has asked that, I would be very keen to continue that conversation. The doctrine of collateral waiver is something which can, of course, or accidental waiver, can take up a seminar in and of itself, but it's absolutely the right thing and a very important question to be asked. It's interesting because quite often we see the sort of the bluff and bluster in correspondence of saying we've taken legal advice, and on the basis of that legal advice, we are acting as follows. I think the real question always has to be, is the advice being relied on? And there is a difference between, on the one hand, someone saying, please rest assured, we've taken legal advice, we maintain our defense. It might be a little harder to argue for waiver in that context. But on the other hand, if someone is choosing selectively to rely on aspects of the legal advice, and so, for example, if they were to say, well, our lawyer has advised us that we have an extremely strong prospect of the court accepting our case on this particular finding of fact or dispute, then the case for a waiver would be much, much stronger. But I'd be very happy to continue that conversation separately. Let me see. Next question. If counsel's advice is taken by insurers as to liability, can it then be withheld from disclosure if requested by the claimant's solicitor? Can I just ask, Bajal, just for clarification, when you say if counsel's advice is taken by the insurers as to liability, is this the claimant's counsel, or is this defendant? I assume defendant's counsel, and have they received their instructions via a solicitor? And it very much.
Hello, hi. Okay,
oh,
yes,
hi.
Hello.
Hello.
It is the defendant's counsel. Sorry.
No, don't be sorry at all. So the situation is you've got a defendant insurer, they've taken legal advice from counsel,
yes,
and the claimant solicitor is asking to see that advice.
Correct, yeah.
I think they'd struggle to get a copy of that legal advice.
Well,
to be honest. I think generally speaking, that would sort of foursquare fall within legal advice privilege. Is there any, I'm suspecting that you may have come across this situation. Is there any particular reasoning that was relied upon by the claimant solicitors for this?
To be honest, I need to look into it a bit more. This is a question that was just raised by one of my insureds, because he's holding fire to say, well, it was taken in terms of how to proceed with the underlying litigation, but counsel has made a reference to say that the insured may be negligent in there. And that's why we're thinking, well, no, let's not disclose it, but the other side are pressing for it. So I just want to know if we can say no, sorry.
I mean, please don't take this appropriately enough as legal advice per se, because I haven't seen all of the material.
Sure.
I would think that you've got a good basis for opposing disclosure, unless the claimant is able to point to some inadvertent waiver or collateral waiver. So, for example, the things that I mentioned in answer to the earlier question, I think it would be relatively difficult for them just to say, purely because you've taken legal advice as to liability, we're entitled to see it. I mean, the only other possibility would be if the claimant was relying on the iniquity exception. So if they're effectively saying that, that you're wrongly trying to hide behind legal advice privilege, where there is effectively unconscionable conduct akin to dishonesty or fraud, or, for example, if there was a cover-up involved, then the court might set that aside. But simply the fact that you might have advice saying, yes, actually, I think that they probably were negligent, I think that falls ordinarily within the scope of legal advice privilege, and it's advice that they're entitled to seek. And the fact that the conclusion is adverse doesn't mean that the claimant's entitled to see it if it's purely a conclusion on negligence. But if you'd like to drop me an email about that, please do so.
I will do. Thank you very much.
One other question here. For infrastructure/project sphere, the in-house team helps the commercial teams bidding on projects by carrying out thought exercises on potential disputes/litigation that may arise given the contractual risks presented in the early stages. Should one of those scenarios arise later in the project cycle, which could be years later, would the legal advice or litigation privilege be captured? That's a very interesting question. And I have to say, I've not come across that one before. So you have a situation where in-house legal team helps the commercial team by giving them considerations of potential disputes, potential matters that could subsequently be subject to litigation. So it's sort of a generalized learning. And then if that scenario later arises, does legal advice or litigation privilege arise? Litigation privilege, I think, would be difficult because you would struggle on those facts, I suspect, to show that the thought exercise was produced for the dominant purpose of conducting or avoiding litigation. And you'd also, I suspect, struggle to show that litigation was in reasonable contemplation, because that's a requirement to show that litigation is effectively more than merely fanciful. It's a real possibility, if not probability, rather than something that may vaguely happen some years down the line, but over which there's no degree of probability. So litigation privilege would be difficult. Legal advice privilege, you may have an argument there, because it could be said that, albeit that it is not advice given in connection with a specific dispute that exists at that time, legal advice privilege doesn't need to be tied to anticipated litigation. So if it were advice, and the key thing really is if the substance of it were truly legal advice, so consideration of rights, obligations, liabilities, and remedies as per 3 Rivers number 6, if that's the substance of it, and this advice is being given purely so that there is an increased legal awareness or understanding, and which may assist the party in complying with the contract, then that may well be legal advice privilege. Of course, as with everything that I've said, it would, of course, turn on the precise circumstances. But one potential analysis of that is that even though these are sort of hypothetical thought exercises in the sense that there's not been a breach or alleged breach of a contract, it is in effect a situation where the in-house legal team is trying to say to the commercial team, here are the risks, and here is therefore how to avoid those risks, i.e. here is how to avoid a situation where you might be found to be in breach. So I think that's a seriously arguable point. Thank you for asking that. It's a very good question. And if you'd like to explore that again, please don't hesitate to get in touch. So I think that concludes the questions. Thank you. If anyone does have any further questions, I'll stick around for another couple of minutes. But otherwise, thank you once again for your time. And thank you to anyone who's attended any of these webinars. It's been a real privilege, genuinely pun unintended, but I knew that was going to happen sooner or later. It's been a real pleasure to host them, and I hope that you found them useful. Please don't hesitate to get in touch with us if you want to ask any further questions. These are very much overviews or snapshots of very complex topics, and I hope that they help you in practical terms. But of course, every case turns on its own facts, and if you do have any particular issues, I'm always happy to help with those. Great. Thanks so much, everyone.